Lissa came to court today for two reasons. First, seeking justice for having been subjected to repeated sexual assaults at the hands of her former ballet instructor during an international ballet competition. And second, she came here seeking protection for her and her family to ensure that she is not subjected to any further harm while this makes its way through the court process. And we're most pleased that she was able to obtain a final order for protection today. I think the turnout of support that you see here today is a testament to the courage that it took for Lissa to come forward, and I'm confident that she will be an inspiration for others who have been subjected to sexual violence and are uncertain about how to address that. As for the process in court today, Lissa filed a civil petition under New Hampshire law seeking protection so that the defendant could not approach her or her family, have access to firearms, or otherwise in any way threaten her during the course of the pending civil proceedings. And the judge has made a finding today that a preponderance of the evidence supports Lissa's account and warrants the protective order having been issued. So for now, a protective order is in place, and it is in place as customary in New Hampshire for a one-year period, after which time it can be renewed by coming back to the court and articulating the need for it to be renewed. At the same time, civil action has been filed in the Commonwealth of Massachusetts against the defendant and against his employer, the New England Movement Arts Ballet Company. And in that action, we have asserted that Mr. Marculatu intentionally sexually assaulted Lissa on repeated occasions. And we have also alleged and asserted that this ballet company failed in its duties of supervision and oversight of the defendant, allowing him to do this. This was a trip that he invited her on at their behest, and they owed her fiduciary duties and specialized care as a student to ensure her well-being. That did not happen, and we have alleged that the company and him personally should be held responsible for that.
I would think that the average person thinking of a sexual assault case that's going through the court process would think that there would be a no contact immediately already in place, but that's not the case. Do you think that that's something that could change after this case?
It is not immediately in place, and you do need to file in order to get that relief. Right now, under New Hampshire laws, there are two ways you can do that. The most common way to seek that protection is through a domestic violence protective order. But that protective order is only available to certain people. And the way that a domestic violence incident is defined in New Hampshire really requires it to involve either family members or current or former intimate partners. But that statute simply doesn't apply to a circumstance like this because there was no former relationship between the defendant and Lissa in this instance. And so the other statute that enables New Hampshire citizens to come forward when the domestic violence laws don't apply is stalking. And it's a broad statute, and it has application here to protect her from threats. But in its common parlance, in its ordinary circumstances, stalking generally depicts something other than a forcible sexual assault. So we do think there's room in an area in the law to review these protective orders and consider whether we should have a process that would more uniquely and appropriately fit the facts of a victim like Lissa who comes forward seeking protection.
What would you advise schools and businesses to protect themselves and their employees from such charges and, of course, the victims?
Yeah. Particularly for any company or entity that provides instruction and guidance, certainly there need to be in place policies and procedures to ensure that people who are exposed to instructors can do so safely. That involves very clear written policies about what appropriate boundaries are between employers and employees, between instructors and students, between those who travel and those who are responsible for their well-being while they travel. And to the extent that companies, employers do not have those policies and procedures in place, they can and will be held liable under the law.